another attempt to start our roundtable discussion. Okay, let's start anyway. We've gathered here today in a rather notable place. I think it is quite symbolic that we are discussing the issues of the development of civil society and the building of the Joint Chiefs of Staff of the Russian Empire. Although the experience of the last 2 centuries has shown that all the things that were planned here were absolutely realistic and well thought through. So I think this will be a very good start for civil society and open government. Open government is a new project for Russia. It is amongst those projects that are of top priority for us, not only because it is required by the political context, not only that we receive recommendations to develop this initiatives from our partners. This is the issue of effective government services and the issue of competitiveness of the country. We know that in today's world, the countries where citizens do not feel comfortable lose in the competition to those countries where citizens feel comfortable, and we are not used to losing battles, and we are not going to. Now I would like to give the floor to one of the authors of the initiative of the open government, Mikhail Abizov, so that he could tell us briefly what kind of achievements we have seen over the past several months since the Russian leadership started to pursue the policy of an open government, and what kind of things we have already implemented. Thank you, Alexei. I would like to thank the organizers of our forum Thank you for including the topic of the open government into the agenda of our legal forum, because without an effective implementation of proposals related to the development of the open government and its incorporation in the legislative framework, the entire system will not function. It is true that the ideology of the open government is quite a novelty for Russia. This is a project that has been developed for a rather short time, but still this project is quite new for the international community as well. It has started to take off over the past 2 years on the international arena. A year ago, the Open Government Partnership Initiative was joined only by 5 countries, but over this year, this number has increased to more than 50. This has become an international program, and we do not have any definitive practices. They haven't evolved yet. For many participants of the program, for many countries, the elements of the open government are new novelties in the system of governance. So international practices are being developed in this field and scaled accordingly. This year, Russia has announced its intention to join the International Open Government Partnership. So what are the principles underpinning this entire system? What is the basis for the work of the entire open government model? First of all, here we are talking about the possibility to extend the maximal amount of information from the government to the society. This refers to the public governance, this refers to economic and social issues. Without giving the society access to open information in the format in which it would be convenient for users to handle it, the open government is not possible, because it is based on free exchange of information. The second pillar of the system and we think it is of critical importance, is the participation of NGOs, the economic community, the expert community in the discussion and decision-making processes. In the world, we have seen a lot of discussions of various models of similar systems, what has been termed crowdsourcing, and in this regard, the system of open government should be conducive to large-scale involvement of citizens and experts and public figures into the decision-making process and supervision of their implementation. This can be carried out both in the legislative and executive branches of power, at the federal, at the regional and municipal levels. These rules are quite universal in themselves. And the third pillar of this system is the provision of government electronic services, whereby the users can respond to the quality of those services instantly. In order to effectively create the open government system, technological platforms and mechanisms are extremely important. We have developed proposals in that regard for Russia. We are going to develop those. We are going to implement those proposals in the near future. The Government Committee on the Development of the Open Government Concept, the Expert Council under the government of the Russian Federation, public councils attached to federal bodies of executive authorities are all involved in the process. The system doesn't have any strict limits. It is developing quite dynamically on the global level and in Russia. It should adapt to the challenges faced by the society. We need to find adequate responses to those challenges, and this is the primary purpose of the system in the first place. We need to create a system of government services, public services that would be adapted to the needs of the population. And on the other hand, we need to streamline the interaction between the society and the authorities. In the day-to-day work, we should jointly seek solutions and answers to the most difficult questions. We are currently implementing our model in line with international best practices, taking into account specific features of Russia. For us, this project is already up and running. Alexei, thank you very much. I would like to say that the working group on the open government, as Mikhail has said, has prepared a wealth of proposals that have been submitted to the government and the leadership of the Russian Federation and the active participation. Well, this working group was organized with the active participation of the NGOs and various government authorities, including the Ministry of Justice. I have a question for the Minister of Justice of Russia, Alexander Konovalov. To what extent the legislative framework of Russia is prepared to adapt to certain openness models? To what extent is it ready to listen to the inputs from the public? What kind of changes do we need to make to the legislation and various other regulatory frameworks that regulate the work of ministries and other bodies? Thank you very much. I would like, first of all, to welcome the participants of the second International Legal Forum in St. Petersburg. As in bicycle races, as in Tour de France, major stages are preceded by the so-called prologue, a test competition of sorts. So we have decided to organize this roundtable discussion as a warm-up, as a preface to the main theme, to the main events of the forum. Maybe it was a very funny idea to place esteemed members of the public on the stairs. You look quite funny from here. You look like students, and I would like to know how, whether we look funny for you, looking down for us. We are not professors, that's for sure, because professor usually is alone and he should be walking from the corner to the corner of this stage. Maybe we look like astronauts that are preparing to go into outer space, and you are just watching our preparations. Maybe they will send us somewhere, but not very far. But okay. But on a serious note, the topic of our discussion is new and outrageous for many, but it is very serious at the same time. We need a totally new, fresh look at the open government system, and this new view should not be purely politological. The open government should be understood in terms of long-term policies and not in terms of political technologies and manipulation that can be used to appease angry citizens or the international humanitarian community by issuing some gestures of attention in their direction. This is sine qua non, a precondition, a prerequisite, which is absolutely vital for the implementation of a certain plan. In this case, the program of open government, which is extremely topical for us. We need to understand that the open government is not a multiplication of the number of ministers, nominal or actual. No matter how many ministers we have, instead of 20, 200 or 500, we're talking about a totally different thing. As a lawyer, I understand that we are trying to create effective and open channels of receiving public feedback at the management and governance levels. When we are talking about jurisprudence and legislative activities, we need here to evaluate the state of current legislation and the practice of law enforcement. At all times and everywhere, the effectiveness of law was defined by the extent to which it was in line with the realities of the life of the society at a certain point in time. But today, this question is as topical as never before. We don't have any boundaries between various strata of the society. We have fewer borders between countries. It means that the world is becoming more and more global, and in order to assess the effectiveness of law, in order to assess whether it is effective in resolving the tasks set by the government and the society at large, we need to understand as clearly as possible what is the current state of affairs in the field of law. And in order to get this information, we need to receive timely signals and messages from those who are involved in law enforcement, from those who are vitally interested in the proper work of the law. What follows from all of the above? Here comes the logical conclusion. To a large extent, in this area, the task of the open government, as it was formulated by the leadership of the country and those experts who were involved in the creative work in this area, it is absolutely in line, in absolute conformity with the work that we started at our ministry 2 years ago. We have decided to bring the system of monitoring the law enforcement at a qualitatively new level. This is the idea: to cover as widely as possible the range of parties in this monitoring effort. And it should be as representative as possible. We should include practicing lawyers, representatives of the legal science, representatives of mass media and advocacy organizations, Nobody knows better than them how the law works in real terms, and this information should be received in on an ongoing basis, and it should influence the law enforcement, the legislative work, the creation of packages of law. I should not go into details at this point, probably responding to the question of our esteemed moderator about specific pieces of law legislation that need to be amended. We need not to replace, but to finally adopt the law on legislation, on the legislative process in this country. This needs to be further discussed, and we have been delaying the adoption of this law, and probably now it makes sense to make this law adequate to the present situation in the society. Thank you.
Well, currently, do you hold any consultations with the civil society, with the public about this legislative act? What is the public opinion and examination of this act? Well, the work on this bill is more or less frozen now, idle, and it should be defrosted. As far as the involvement of the civil society is concerned, I think that the monitoring, public monitoring, should be put into the basis of this work. We have established constant contacts with human rights associations, lawyers associations, etc. And the more people would come to us, the bigger this information flow will be, the better it will be. Open government suggests some interaction, that the citizens become co-participants of both government decisions and government policies. And in this regard, I have a question to the representative of the Netherlands, to Mr. Dominic Joris. What is the situation in your country with the ability of citizens to exert influence on the activities and decisions of the government? And I know that you really try to assess whether citizens are satisfied with the activities of the government. And I wonder whether there are any legal consequences when you reveal that the public is not really satisfied with the government. Thank you.
Thank you very much. May I first say how very much impressed I am with the way this forum is organized. It's a big compliment for our hosts that they've managed to make it even more impressive than it was the first time. And I'm glad that we're all extremely pleased that we were invited to take part, which is indeed a great pleasure. As to your question, of course, there are various levels on which you can discuss open government and the way you can take into consideration the opinions of the population at large in what governments do. First of all, it's a way of organizing your democratic system where we at least try to have as much as possible decisions to be taken at the lowest level, whether that is a municipality or a province or finally the nation as such. But we have over the past decades decentralized a lot of decisions to local government, which is a way to bring decision-making nearer to the people, of course. On the other hand, when it comes to legislation, nationwide legislation, it's the only way to achieve anything there, of course, is to make a national law, which in due time will be debated in the national parliament. we have found that it is most helpful before you put an important proposal of law to Parliament that you have consultation with the public at large. So a few years ago we started an experiment that turned out very satisfactory with online consultation on legislation. And that is to say that we publish on a website of the Ministry of Justice a proposed piece of legislation, and we invite the public at large to comment, react, give their opinion, whatever. This has been a great success, especially because all kinds of non-governmental organizations, interest groups, professionals from the various professions find time to react to that kind of proposal, and we really learn from it, not only in a technical way, because there are always aspects that you have neglected or that you have not given sufficient weight to, but also to get a feeling how a proposed piece of legislation in the end will be accepted by those for whom it's meant. So after 2 years of experimenting, we are now on track to organize our legislation process in such a way that every really important draft law will be put on the internet, and the public at large will be invited to react and give their comments. And we find it useful to improve the quality of legislation, but we find it even more useful to improve the acceptance of legislation. Thank you.
Well, thank you very much. I wonder, when the public is involved in discussing various legislative proposals and bills, I wonder whether you would seek some professionalism there, because it is an open secret that it is not only lawyers who are professionals that are involved in such discussions, but also general public who are not members of this professional legal court. So I wonder whether non-professionals are really important for such proposals and discussions.
Well, maybe not as to the quality of the proposed legislation, and I do have to admit that in organizing this kind of consultation, you burden your system in some way, because you get a lot of reactions that are not very useful. So you have to sort out the reactions that you can use and those that you cannot use. On the other hand, as to the acceptance of the proposed legislation, it's very important that everybody, whether he is a specialist or not, is in a position to react, even if his reaction does not tell you anything about the quality of the law, but maybe it tells you something about the acceptability of the law. But it's a lot of work.
Если уважаемый модератор не позволит, буквально на минуту вмешаться, я обещаю...
If I may intervene for a couple of minutes, I would promise not to interfere anymore, and then I will have actually to leave because I have some negotiations planned later on. I think that the question that was asked was actually a question which is very much related to the functions of juries. Well, I mean, some people claim that general public simply cannot understand the aspects, the elements of law if they're not professionals. But in many situations, this technology of involving jurors to hear a case is quite acceptable, and it is actually useful for a law. We should say that let us not puzzle people with very complicated legal terminology, where people simply cannot deal with such terminology notions without the involvement of professional lawyers, and they waste much time. But relations between people are quite simple, and all those highbrow legal terms, derivatives and stock exchanges, etc., these are all areas where only few people are involved. But we are talking about simplicity for the general public, and this is a way to demonstrate respect to people and vice versa. Thank you. One of the priority key tasks for the open government would be to provide comfortable government services to the public. And I would like to ask Mr. Lenny Brewer how processes are organized in the US to provide comfort and convenience to the public in using government services, and whether such government services should be universal at all levels of the government. I'm talking about federal level and local level.
Thank the organizers, the Minister of Justice, the Deputy Minister of Justice for inviting me here today. I'm here, the Attorney General is here today, and a number of our lawyers and staff from the department, and it really is, Mr. Minister, because of your extraordinary leadership and the leadership of the government and the President's advisor in bringing so many together on this very important issue of open government. And I just want to begin by saying our relationship, as far as I can tell, has never been stronger. And over the last couple of days, I was at Moscow State Law School and then at St. Petersburg Law School yesterday, and the future of your country, at least with respect to young, brilliant lawyers, is very bright. I think that the idea of openness in government and making government decisions accessible goes really to the core of making a government vibrant, functional, and able really to meet the needs of its people. And it's a balance that we at the Department of Justice are always trying to deal with. The President Obama, when he ran for office, stated that our administration would be the most open. And our Attorney General has said that as well, and we're committed to that. And the way we do that is, whether on the state level or, in our case, on the federal level, we attempt to make our decisions as transparent as possible. We recognize that all citizens won't agree with what we're doing. We recognize that our Congress will not always agree with our legislative efforts or our prosecutorial decisions, our strategies in general. But what we try to do is, in the most open way we can, to make it clear why we are doing what we're doing. And then we let the marketplace of ideas be the determination of whether what we're doing is effective or not. And so that has really become the hallmark of our administration. So when my criminal division brings cases, we have many press releases, we have Twitter accounts, we have press conferences, and we have legal pleadings where we really lay out as much as we can why we are doing what we're doing. We want this exchange of ideas in the marketplace. So, for instance, right now in our division, we have a very high-profile case going on. We have a criminal case where we have charged a former United States Senator and candidate for Vice President and ran for President, Senator Edwards. And just yesterday, one of the newspapers criticized us and criticized me for bringing the case. But we think that's good, because at least the country knows why we're doing what we're doing, what the basis of it is, and we think that that's healthy. In trying to be as public as we can, not only do we have press releases, not only do we have Twitter accounts, not only do I give and others, the Attorney General, press conferences and meet in fora, not always as grand as this one, but I speak in the United States and around the world. But we also try to do it through the kinds of work we do. So we have brought many cases under our Foreign Corrupt Practices Act. And why do we bring cases about foreign bribery? Well, we prosecute cases about corruption both domestically and internationally because our view is that bribery is one example that violates openness in government. It violates transparency. If a mayor, a senator, a congressman in my country makes a decision based on receiving a bribe, in our view, that's the antithesis of openness. That's doing something because of private gain, not for public good. It's doing something in the shadows, in the dark, not in the openness of light. And so that has become a very large priority of ours. And in bringing those kinds of cases, even something like the Foreign Corrupt Practices Act, we've tried to be as open as we can. So we have websites that show as open as we can every case we bring, the pleadings in every case we bring. And right now I've had meetings with all kinds of business groups, not-for-profit groups, all kinds of different compliance groups to speak about the law, to speak about how we implement the law and why we implement the law. And in the next months, we will be also offering up a guidance, which will be a large document that will explain the past cases we've brought, our interpretation of the law. And again, it is so that there's no mystery as to why the Department of Justice does what it does. And in our world, where, of course, we have the ultimate sanction, which is taking away somebody's liberty, there can be no greater power in a government. We want people to understand how we use this very important power. We hope we use it in an appropriate manner, and we welcome criticism because we think that's the appropriate check and balance. Thank you.
Well, thank you very much. If I may to ask another question. The U.S. Is a federal country consisting of a number of states, plus there is a developed local government system. But are there any transparency requirements for all those individual states, or each individual state would have the power to decide on the level of its transparency? Also, are there any unified standards of information transparency on the federal level, or these are all decided individually in each of the states? Thank you.
Well, with respect to our states, you're absolutely right. In our federal system, we have 50 state governments. Each governor, each legislature has discretion in how it's going to implement some of its law. But as a bedrock principle is our Constitution, and no state can ever violate the federal Constitution. There is a level of transparency that's required through our Declaration of Independence and our Bill of Rights that really requires a level of transparency in all states. Now, each state has an ability, if it wants, to maybe be a little more transparent, or to do it in a slightly different way, and let the voters decide whether or not what it is doing is adequate. If the voters in a state, for instance, feel that the legislature is not transparent enough, they have a right to vote out those state legislators and bring in others that want greater light. But because of the Constitution and because our independent judiciary interprets the federal Constitution and also individual state constitutions, there's at least a baseline that, at least in my view, requires and results in a fair bit of transparency. Even the minimum in any state will still be fairly good.
Do I understand you correctly that if a citizen of the US is not satisfied with the level of transparency of a local body of government or say who is not satisfied with the government of the state, then this citizen would go to court first, right?
Well, one option would be that. So we have a law called the Freedom of Information Act. It's a federal law, and it requires at least the federal government to disclose many materials. And if we in the government decide that the citizen wants more than we think is appropriate, someone makes a request of me to open up criminal files in an ongoing case, I would say, and my lawyers, I would hope, would say no. In this particular case, we cannot provide what you want because there is an ongoing case and it's too sensitive. That person has the right, if he or she chooses, to go to our court and to say that Lanny Breuer and the Department of Justice have it wrong. The judge will ultimately decide based on the law. The same is true in the states. I believe each of our states has the same kind of a law, and each citizen has the right, if he or she chooses, to go to court as well. And our courts, of course, because we have checks and balances, we have equally powerful executive branch through the president and the departments, the legislature through our Congress, and the court system through our courts, and that checks and balances is replicated in each of our states throughout the country.
Благодарю вас.
Thank you very much. I would like to turn to our colleague and guest from the UK, Wanis Lansing, the director of the Institute of Global Law. In Great Britain, services providing for the openness of not only authorities at the level of the country, but also at the local level, with regard to the criminal rate, to the rating of schools, to the number of successful operations in hospitals and failures in hospitals. Are these procedures initially envisaged by the UK law, and are they regulated, or are they actually the manifestation of goodwill on behalf of local authorities and representatives of medical and educational bodies?
Thank you very much for this question and for your invitation. Before answering this particular question, I would like just to mention a few things about the way we can conceive open government, which I think has very multiple kind of dimensions. I would say the first one, which we touched upon previously, is the issue of transparency. And I think that's extremely important, and that basically comes through access to documentation, from a passive duty, let's say, to open access to documents to the citizens through Freedom of Information Act type of requirements, as in the United States, or as in the European Union, the Regulation 1049 of 2001. But also that includes a proactive release of information, and this is basically what you're referring to happening in the United Kingdom, in the sense that the local authorities as well as the government, they are trying to inform and take active steps to inform the citizens about the different conditions that exist in their territory concerning, for example, the quality of schools, but also concerning the different activities they do through websites and providing this information through websites, or actually through databases that they make public to the general audience. But I think the second aspect of it, and I think if we think about open government, we should think of these two dimensions together, is participation. So it's not only about transparency, but it's also about participation of the public to the decision-making process. And I think transparency can be seen as a first step towards participation. And there, I think, not only in the UK, but also in the EU, there's been considerable progress lately. Because firstly, it is to identify expertise and talents. And a quite interesting way was followed by the former Greek government, for example, where they publicized the positions of secretary generals of the ministries publicly, and they asked everyone able to present themselves and to apply for these jobs. But secondly, it's also about extending the way the government consults with the public. In the EU, we had the tradition of lobbying that was pretty heavy. We had around 1,200 lobbyists and more than 120 consultative committees of the Commission with lobbyists. But the idea of the open government is to open that small group to all the different citizens that would like to comment on a particular legislation or preparatory document. And as well as in the UK, as well as in the EU, the European Commission, for example, when they take a particular legislative initiative, they ask submissions from the public, whoever that is, which are published later to the website of the European Commission, and that are used as documents for preparing the legislative, let's say, proposal at the end. So it's kind of an holistic perspective, not just transparency, but also participation.
Thank you very much. Do you envisage legal channels for the communication of the public? Because there are different ways of communication. You may have a face-to-face meeting with a bureaucrat, an official. You may write a letter. You may send an email. You may participate in an electronic forum. So each time there are different levels of identifying a person, an applicant. Because when you come in person, if you call by telephone, if you send an email, you cannot always identify whether the person is actually what he is claiming for. So what are the procedures to take care of the identification and the level of response to a specific query?
Thank you. I think we have to understand the concept of open government in terms of what are their objectives, what we're trying to achieve. And I think what we're trying to achieve really is to ensure a public space in a way the German philosopher Habermas basically called Öffentlichkeit. So this idea of public space obviously has to be regulated somehow in the sense of providing means and instruments for that to be achieved. So I think instead of, let's say, creating some form of insisting on this form of the one-to-one process with the idea that you have to respond to emails, etc., I think much more interesting are the obligations imposed to the government in terms of consultation mechanisms or rendering them public through the internet, making sure that there is this type of public space, which I think is the objective of open government, creating this public space.
Благодарю вас.
Thank you very much. I have a question to Brewer Lenny, Deputy Attorney General of the USA. You have rightly stated that open government is an ideology and setting up public space, but any official is actually regulated by rigid rules and guidances that are spelled out by the legislation and regulatory framework. So are there strict rules in the USA how an official must react, a federal official or a state official or a municipal official must react to public queries?
Like everything else, it's a balance. So a good example is our government tries to be as transparent, as open as it can be, but there's certain things that we can't do. In a criminal investigation in our system, before we bring charges, we present a case to what we call in the United States a grand jury. And it's a group of citizens who hear a matter that the prosecutor presents, they hear evidence, and they make a determination whether, in their view, there's probable cause to bring charges. Only after the grand jury votes that there is probable cause do we then issue an indictment. That's a public document, and that is the first time that I would ever announce that we have a criminal investigation and a prosecution. Before then, there may be rumors, there may be a big case, it may be in the newspapers, and I and my colleagues will be asked if we have an ongoing investigation of well-known person A or company X, and we will refuse to answer. We will refuse even to say whether there's an investigation at all. That's because under our law, there is absolute secrecy, grand jury secrecy. That's done to protect witnesses. That's done to protect the reputation of a person who may be the subject of an investigation. And the theory is that if there is not probable cause and there is not an indictment, or if we choose not to go forward, that person's reputation should not be unnecessarily hurt. That's an example where secrecy and privacy becomes greater than transparency and letting someone know what's going on, because we believe that it's important to safeguard the reputation of the person. Once those charges are brought, I can only speak about those allegations that are in the indictment. I cannot begin to speak, both under the law and under our own department's policies, about other evidence that we may have, other theories that we may have. And so if I do a press conference after an indictment, I will always say, it is alleged in the indictment that Mr. X did the following, and I will follow very strictly what is in the charging document. And again, it is simply the balance between being open, trying to be as transparent as we can, while also safeguarding a very other important principle of not unnecessarily hurting or besmirching the reputation of someone, and letting our real actions be proven in the court. It's our balance.
Спасибо.
Thank you. I have a question to the President of the International Union of Notaries, Jean-Paul Decaux. The international experience indicates that open government provides for several levels of interaction. It is not only interaction between the government and the public, but between the government and the business community. So from your point of view, what are legal prospects and what is future under a more transparent, more open system in terms of interacting of governments and businesses in settling disputes with regard to the participation of foreign companies? Well, is it becoming global, or will each country follow its own way? Good afternoon. I would like, on my behalf, to express gratitude to the organizers of the forum to take part in this second international forum. Great thanks to the Ministry of Justice and my colleagues, notaries from Russia. We are talking about modernization of government, and this modernization must be for the benefit for the transparency, efficiency and openness. International experience has demonstrated that this modernization becomes focused on the evolution of a state, its development, because a modern state must focus on its main functions: justice, defense and diplomacy. Of course, a state is not omnipotent, but it must react to the changes in society and serve for the benefit of the interests of the public at large, and the legal system in the state must be a sort of intermediary between the functions of government, its regulatory functions, and hence notaries here are an intermediary link between the public and government, which is a two-way traffic. A notary must explain legal standards and apply thereof, but as lawyers, as bailiffs, notaries are representatives with regard to the government when they express interests of the public at large. I know that in Russian Federation it is this very function that they perform, and a notary is also a partner of the government. You're asking about business structures. It is here that a notary provides for legal safety and security, because without it, no development of the state can take place, no investment will evolve. So the legal system is a partner of the government in its interaction with the business community. So we may talk here about the transparency of the government. An authorized act is transparent, it is registered, it provides for the documentation turnover, and hence the government focuses on its main functions, while notaries in the system of the civil law and our International Union of Notaries represents 1/3 of the population, more than 80 countries that have adopted civil law. So actually, they are the translators of these partnership relations between the government and the public. And there is wonderful mutual complementarity in this partnership. We call it public-private partnerships in Europe, and it is exactly civil law that provides for it.
I would like to ask a question and address it to Tim Wu, the professor of law from Columbia University, USA. The thing is that in the United States are one of the countries where laws pertaining to lobbying are developed to the highest level of detail. And this somehow enhances the opportunities for the public and the businesses to make proposals to the government. In the conditions of the open society where more people and more companies are involved in direct contact with the state, does it lead to changes in the lobbying process in the United States? And is it possible to introduce some innovations in the lobbying activities in your country and globally from your point of view?
Thank you very much. It's a pleasure. Thanks. Like everyone else, I'd like to say it's a great pleasure to be here. I don't think I've ever been in a room this big in my life. And I want to particularly say that this Russian version of the iPad has been very nice to use, and I appreciate this gift. So the question of the influence of open government initiatives on lobbying is a very important question. I think the premise, the original premise, particularly of the Obama administration's open government initiative, was to try to decrease some of the influence of lobbying on the American government. And I think that's a challenging prospect. In theory, the open government initiatives, to the extent that they improve transparency, are supposed to give the public the same access to what the government's doing that lobbyists have. And so in theory, at least, members of the public are not at a disadvantage compared to people who who are involved in a professional basis on trying to influence the government. I would say this is a little easier said than done. The challenge with open government initiatives is that, as in all things, it's those who have the time or the incentive to influence government who end up having the most influence. And the average citizen has a job and a family and things to do, and often doesn't find that he or she has the time to invest deeply in an issue and try to influence the government. Nonetheless, I want to suggest that in the end, not everything, so I'm suggesting in some ways lobbyists, the lobby process hasn't been exactly undermined by open government procedures. But I do want to suggest that there is an important influence that open government procedures have, and it's the following. They are very potentially a check on power, even if they don't involve every citizen. Even if a day-to-day decision continues to be somewhat underanalyzed by the public, the fact that the government is releasing more information can ultimately have more of an effect of checking the power of government. This, however, depends on two essential preconditions. First of all, the public has to feel a sense of freedom to speak without being punished. That is to say, I think the most important part of an open government initiative is an effective enforcement of free speech laws. In America, First Amendment is an example, and there's obviously other examples across the country, but it is meaningless to have an open government initiative without having effective free speech rights. Second of all, the most likely users of the information that is disseminated through open government procedures is, in addition to lobbyists and other interested individuals, is the press. And so open government initiatives work hand in hand with an effective press as a check on power. That is to say, you must have effective freedom of the press for an open government initiative to have any real influence. So I think these two things are important, that there would be a precondition of free speech, a press that feels free to speak without being punished, and then you will therefore have an effective open government procedure.
Thank you very much. To what extent, from your standpoint, the transition to contactless interaction between members of the public and officials is involved? When this interaction is carried out online, when a member of the public can address an official in a distant mode, which probably excludes any possibility of abuses on the part of the representative of the state. So this distant mode of communication, is it important, and how well regulated should they be?
It's an interesting question. I am speaking only for my individual behalf, but when I did work in the government, it was interesting to see how the public did interact with government. And I would say the most effective way that members of the ordinary public reached government was not through face-to-face emails, was not through emails or Twitter or something else, but most commonly was when someone takes the time and effort to put together a very effective blog and has the freedom to develop a body of writing which the government may become interested in. Some of the decisions the government gets involved in, I think the government officials will pay attention to bloggers who take the time and effort to really devote some attention to the problem. Open government initiatives work best when they seize upon expertise in the public which is not otherwise being tapped. And in my experience, the most effective way of the public, a member of the public who isn't something of an expert in the area of communicating to the government, is by developing a blog. And I want to re-stress that, therefore, the blogger must feel a certain freedom to write without being punished and without being, in some ways, being able to get in trouble. And I think in that sense, this is the most effective tool of communication between government and governed.
Thank you very much. I would like now to give the floor to the representative of the Parliament of Russia, the State Duma. Eldar Gudrahmanov, and I would like to address the following question to him. Could you please tell us, well, taking into account those mechanisms of open government that are currently evolving and discussed in the society, do the citizens acquire a possibility to influence the work of the parliament more frequently than once in 5 years when they come to the polling stations? How the work of State Duma with the public is currently organized? Do you have certain level of interaction whereby citizens can exert certain influence or express their opinion with regard to those bills that are submitted to the State Duma? Thank you for your question. The Parliament, the State Duma, are extremely interested in the mechanisms of open government that have been discussed here today, because the reputation of the Parliament, the authority of the power, can be enhanced through more openness of its work. In order for people to have greater confidence in Parliament, they need to understand that their proposals will at least be heard and ideally be adopted. And the Parliament, on the one hand, already has quite serious mechanisms of ensuring public participation. Any bill that is discussed in the Parliament is published beforehand. All the hearings are openly discussed. Any amendment cannot be discussed in the Parliament if it hasn't been published. But of course the legislative process is a complex one which involves many stages, and when we say that more experts, more citizens should have a say in order to improve the piece of legislation, but when the bill gets in the Duma and is adopted in the first hearing, in the second hearing can be significantly reworked, and we need to have a chance to listen to what the public has to say as well, the expert community, so that the initial idea is not transformed in something totally different from the original plan. And what refers to greater attention to the public opinion, we are now working on a system that would allow us to get proposals from the members of the public via the internet, and those proposals will be about specific pieces of legislation under discussion. And this system should not simply receive those proposals. This proposal needs to be somehow formalized. Otherwise, the system will be superficial and people will send their wishes or recommendations and it will remain a wish. But this wish needs to be somehow considered and responded to professionally. Whether we should explain why we support or do not support this or that proposal. And those principles of the open government that have been stated here are of great interest for us as parliamentarians, because once again, this will enhance the authority, the level of trust by the public. In many countries there are so-called electronic petitions, whereby the citizens can collect electronic signatures and submit a certain proposal or an idea aimed, well, to the bodies of state authority or the parliament. From your point of view, the idea of electronic petitions in Russia, to what extent can it be useful and applicable? I think this is a very interesting proposal, although it is quite clear that according to the Constitution, the number of bodies that have the right of legislative initiatives is limited, but I think that those who have the right of legislative initiative will be happy to propose laws that are supported by the majority of the public. The thing is that it should be previously discussed by the public. The transformation of proposals of citizens supported by a large part of the population. We can, of course, establish a certain number of people that need to support number of people who support the bill. The problem is how to create this mechanism? How, in what format shall the proposal be worded? How can it be translated into the correct legal language? And it should go through all the stages of public hearings. Thank you. We are coming to the end of our roundtable discussion, and my two final questions to Mikhail Abizov, who started this discussion here today. The first question is as follows. In many countries of the world, before they started the work on the organization of open government, they had studies of the public opinion, trying to understand what the public is willing to see on that front. In Russia, opinion polls have shown that many citizens view the open government not simply as a possibility to learn something about the powers that be, not only the chance to ensure greater transparency of the authorities, but also as a way to enhance the level of the quality of government and public services. People are disillusioned not only by the lack of information, but the lack of communication with the government. In the Russian-style open government, to what extent are you going to pay attention to the level of convenience for the citizens in their interaction with government entities? Thank you very much, Alexei, for your question. As part of this work, we also carried out opinion polls. We were trying to understand which issues are the most topical for our public in terms of their interaction with the government. What kind of priorities do the members of the public put forward with regard to those relationships? In what refers to public and government services, in what refers to taking into account the views of the public in legislative activities, in working out regulatory frameworks. Our citizens are concerned to the greatest extent by the quality of services that they receive from the government, not only at the federal level, rather at the level of the municipality, where people live and where they come across government entities. A person who lives in Siberia, in the Far East, in Alaska, in the States, they come across the government not only in the capital, they come across government bodies where they live. Representatives of government for him are the municipality, the policeman on the corner, the healthcare service, the public utility service. And it is at this angle that people approach to defining the quality of service provided by the government to the public. Therefore, of critical importance, it is, well, when we are talking about creating the open government, the most important thing here is not only the general principles adopted at the federal level. The open government and the open state should exist at various levels and in various aspects. It means openness in the work of the State Duma, in the work of the Ministry of Justice. The open government should be manifested in providing elementary municipal services. People's opinions should be taken into account. We should monitor whether the citizens are satisfied with the quality of service they receive. We should start from the level of our day-to-day life. We should enhance the level of competences amongst the people as users of government services. We should teach them that they can exert a certain level of influence on the quality of service they receive. And this will help us to significantly enhance the level of education of people as citizens. This will ensure their participation in the work of the government not at the municipal, regional or federal level. We need to train people as citizens. We need to train people who come in contact with government bodies. They should be trained. We should help them in implementing their initiatives that should be taken into account through the open government by the authorities at large. This is a long way, of course, but we should start moving along, starting with the level of municipality, where people come into contact with the state in everyday circumstances, and all the way to the federal level, where the society and the authorities interact at the level of the parliament and the government of the Russian Federation. The open government means that we create an open state as an embodiment of these principles that have been discussed here. Of course, this is a long and winding road. We should move forward along this path together with our international partners, and I would like to thank our colleagues from different countries of the world who have taken part in this roundtable discussion. For me, it was extremely important today to talk about the following: how the open government principles are reflected in the work of legislators and lawyers, because the government, the state, is based on the rule of law, and involving people in day-to-day government activities, we should not dilute the limits of state authority and the limits of law and the legislative frameworks. They need to be amended, they may need to be upgraded, but by involvement of people should not substitute such institutions as law and legal frameworks. In this delicate interaction and interplay, we should seek the effectiveness that we were talking about here today. And the issue of legislative support, the work of the legal community in this area is extremely important in the process of organizing the open government system. And this is the groundwork of an effective open government. I would like to thank my colleagues for participating in this discussion here today. Thank you all. I would like also to extend my gratitude to all the participants of our roundtable discussion. And now, in conclusion, I would like to open a secret why the organizers of this event organized this discussion exactly here, in this place, in this room. They thought that this room ensures is in conformity with two main principles: transparency, because we have a transparent ceiling here, and openness, because the organizers promised to open gigantic doors, and we will see whether they will be successful in that or not.
Спасибо.
Thank you.